You are sitting in the driver's seat, heart rate up, eyes locked on the mirror. You are watching the officer get out of the patrol car behind you. And before they even take 3 steps toward your vehicle, they reach out and drag their hand across the back of your car. You felt it, maybe you heard it, that distinct thump against your trunk, and you have absolutely no idea what just happened or why. Here is the truth. That touch was not accidental. It was not a nervous habit. It is not some cop quirk passed down through the generations like a baseball player tapping home plate. It is a deliberate, trained technique, and it sets off a legal chain reaction that most drivers do not even know is happening to them in real time. And if you do not know exactly what to do in the 30 seconds after that hand makes contact with your car, you may have already handed the officer something they can use against you before the conversation even starts. I have spent months reviewing attorney consultations, depositions, body cam footage, and Supreme Court rulings on traffic stop law. What I'm going to walk you through today is the exact same information that defense lawyers charge hundreds of dollars an hour to explain to clients who are already sitting in trouble. You are getting it before the trouble starts. Subscribe right now, because this is the video that most people only find after something has already gone wrong. Do not be that person. Here is exactly what we are covering. I'm going to tell you the real reasons officers touch your taillight. And there are 3 of them, not 1, and the 3rd one is the legal trap that is specifically designed to work against you. I'm going to give you the exact physical moves and exact words to use the moment that touch happens. I'm going to walk you through the 4-phase framework that defense attorneys say gives you the strongest legal protection from the very first second to the very last. I'm going to show you the wrong way and the right way side by side in a real scenario so you can see the difference in outcome with your own eyes. And I'm going to tell you what to do after the stop ends, because that step is one almost every driver skips entirely, and it is the step that can make or break your case if things ever go to court. Every single thing in this video is 100% legal. It is backed by Supreme Court decisions. It is used by practicing defense attorneys in real courtrooms right now, and by the end, you will never sit in a driver's seat the same way again. Let's start with what is actually happening the moment those lights come on behind you. Most drivers believe a traffic stop works like this. Officer pulls you over, you hand over your license and registration, you get a ticket or a warning, you go home. Minor inconvenience, slightly embarrassing. Done. That is not what is happening. From the exact second those blue lights activate, the officer has begun building an observation record. They are watching how quickly you pull over and where. They are watching whether you brake hard or ease gently to the shoulder. They are watching your hands through the rear window. They are watching whether you move around in the vehicle, whether you reach for anything, whether you look back at them, whether your hands disappear toward the passenger seat or the glove box. Every single one of those observations is potentially going into a written report, and then they walk up and touch your taillight. And a very specific legal process begins. Here is what most drivers do in that moment. Nothing. They do not register it. They are already stressed about the stop, already worried about the ticket, already thinking about being late or about their insurance rate going up. They are not thinking about the fact that a legal process just began that they are completely unprepared for. Defense attorneys will tell you the same thing every single time. The drivers who end up in the worst situations are almost never the ones who did something dramatically wrong. They are the ones who did not know what was happening to them and responded instinctively instead of correctly. So let's fix that right now, starting with why that touch happens at all. There are 3 reasons officers touch your taillight, and most people only ever hear about the first one. But the 3rd reason is the one built specifically to work against you, and it is the reason this video exists. The first reason is evidence preservation and officer safety. When an officer touches the back of your vehicle as they approach, they are leaving a physical fingerprint on your car. That fingerprint places them at that specific location with that specific vehicle at that specific time. If something goes wrong during the stop, a confrontation, an injury, a driver who flees, that fingerprint is forensic evidence tying the officer to that vehicle. This practice became standard in many departments decades ago, before dash cams and body cameras were common. Officers needed a way to physically document their presence at a vehicle. The taillight touch was that method. Many departments still teach it today as a fail-safe backup, even with modern camera technology. That is reason number 1. It is about them, not about you. The second reason is a physical safety check. When an officer presses down on the trunk, they are doing more than touching the surface. They are checking whether the trunk is fully latched. Why? To make sure no one is hiding inside, ready to emerge from behind you. It is a survival instinct built into the approach. Fast, subtle, and almost invisible to most drivers watching from the front seat. But reason number 3 is the one that directly affects how your stop unfolds, and most people never learn it. Some officers use that touch deliberately to create a startle response. They want to see how you react to an unexpected physical contact with your vehicle. A flinch, a sudden turn of the head, a quick reach toward the center console or the glove box, a visible jolt of panic. Any of these reactions can be observed, recorded, and documented in a police report as what the law calls suspicious behavior. In a report, that flinch is not just a nervous reaction. It becomes furtive movements. It becomes an articulable fact. Here is why that matters legally. Officers need what is called reasonable suspicion to escalate a stop beyond its original purpose. Reasonable suspicion means a specific, articulable reason to believe criminal activity may be occurring. It is a low legal bar. It does not require proof. It does not require certainty. It requires only that the officer can point to specific observable behaviors and explain why those behaviors suggested possible criminal activity. Under the landmark case Terry v. Ohio, decided by the Supreme Court in 1968, that standard is clear, and your physical reaction to the taillight touch can become that articulable reason. A report that says, "Driver made a sudden movement toward the center console upon my approach," is not nothing. That line, in combination with other observations, can justify extending the stop, requesting a K-9 unit, or asking questions well beyond what the traffic violation requires. A 5-minute speeding ticket becomes a 45-minute roadside investigation, triggered not by what was in your car, but by how your body reacted to a sound. This is not hypothetical. Defense attorneys have reviewed thousands of police reports and watched this exact language appear again and again as the justification for stops that escalated into searches, into arrests, into prosecutions. You need to know this is happening so you do not hand it to them. The moment you feel or see the taillight touch happen, there is one physical priority above everything else. Both hands go to the steering wheel, and they stay there. Not near the steering wheel, not resting in your lap. On the steering wheel, visible. Still. 10 and 2. You do not turn around to look at the officer. You do not reach toward the glove box to get your registration ready. You do not pull out your phone. You do not adjust anything. You sit completely still, you breathe, and you wait for the officer to come to your window. Turn off your engine. Roll your window all the way down, and do not move. This is not passive. This is strategic. You are removing every possible observable behavior that could be written into a report as suspicious. You are giving them nothing. When the officer reaches your window, you say exactly this. "Good evening, officer. My hands are on the wheel." 8 words. That is the complete opening statement. Nothing else until they ask you something directly. Notice what those 8 words accomplish. They open with a neutral, respectful greeting. They immediately announce hand position, which is the single biggest officer safety concern in the first moments of any stop. And they stop there. No volunteering of information, no nervous chattering, no over-explanation. And critically, you are creating a verbal record on their body camera that you are being fully transparent with your physical presence from the very first second. Now here is the wrong way, and you need to see it clearly, because most drivers do this without even thinking about it. The moment they stop the car, they immediately reach across to the glove box. They are trying to be helpful. They want to have their documents ready before the officer even arrives. What the officer walking up sees through the back window is a silhouette leaning over and hands disappearing into a dark closed compartment. That observation goes directly into the report. Upon approach, I observed the driver reaching into the glove box area. That one sentence has escalated routine traffic stops into full criminal investigations. Not because of what was in the glove box, because of what the movement looked like from outside the car. The right way, hands on the wheel, still, calm. Wait, greet with the 8 words. When the officer asks for your documents, you respond with this. My registration is in the glove box. May I reach for it? That question changes everything. It announces your intention before you act on it. It eliminates the element of suspicion before it can even form. It demonstrates complete transparency in a way that is very difficult to characterize as threatening or evasive in any report. You have survived the initial approach. You did not flinch at the taillight touch. Your hands are visible, and you have handed over your documents without making any sudden moves. Most drivers at this point take a deep breath and think the hard part is over. They are just waiting for the ticket now. This is actually where the most dangerous part of the stop begins. The officer has gone back to their patrol car. They are running your plates, checking your license status, writing the ticket or the warning. And while that is happening, the stop feels like it is almost over. It is not almost over. This is where the second and most dangerous phase begins. When the officer comes back to your window, they are trained to use the return of your documents as a transition point. They hand you back your license, and in the same breath, before you can even put the car in gear, they shift from traffic enforcement to information gathering. The questions feel casual. They are designed to feel casual. That is entirely intentional. So where are you headed tonight? You live around here or just passing through? Have you had anything to drink this evening? Not even a beer with dinner? Long day? These questions are not part of the traffic stop. They are not required for the ticket to be written or the warning to be issued. They are voluntary conversation, and every single answer you give is available to be written down, included in a report, and used. Here is the legal reality that most drivers do not know until they are sitting in a courtroom. You are legally required to provide your driver's license, your vehicle registration, and your proof of insurance. In most states, you are required to provide your name if asked directly. That is the complete list of your legal obligations during a traffic stop. Everything else is voluntary. Every casual question, every follow-up, every friendly inquiry. You are under no legal obligation to answer any of it. This is not a technicality. This is a constitutional protection. The Fifth Amendment right against self-incrimination, confirmed by the Supreme Court in Berkmer v. McCarty in 1984, applies during a traffic stop. Not after arrest, not after Miranda warnings, during the stop on the side of the road, before anything has been formally charged. Most drivers think that by answering honestly, they are showing they have nothing to hide. They think cooperation leads to leniency. But the officer asks where you are coming from. You say you were at a friend's place. They follow up. Have you had anything to drink? You say just 2 beers over 4 hours. You are totally fine. Stop right there. You just handed the officer probable cause. By admitting to consuming any alcohol, you have legally justified a field sobriety test. Even if you are completely sober, those tests are performed under high stress on the side of a highway, and they are easy to fail. Once you fail that test, the handcuffs come out, all because you tried to be friendly during what felt like small talk. Here is exactly what you say instead. Calmly, without attitude, without nervousness, without any show of agitation, "Officer, I'm happy to provide my documents, but I'm going to respectfully decline to answer additional questions." Say it once. Keep your voice even. Do not repeat it with escalating emotion. Do not explain it. Do not justify it. Do not apologize for it. One clear, calm statement and nothing more. The officer may push back. They might say, "Why are you being difficult?" They might say, "If you have nothing to hide, why won't you talk to me?" Do not take the bait. Your silence is not suspicious in the eyes of the law. It is a protected right. And knowing when to use it is the difference between a traffic stop and a criminal proceeding. Defense attorneys say it consistently across case after case. The evidence that does the most damage to a defendant is not physical evidence found during a search. It is the voluntary statements made on the side of the road during what felt like small talk. Statements the driver was never legally required to make. Drop a comment right now that says, "Know your rights," if this is already changing how you think about every stop you have ever had. Because the next phase is where most drivers, even the cautious ones, make their biggest and most costly mistake. Here is the scenario. The officer has run your plates. They have written the ticket or decided on a warning. They walk back to your window. They hand you your license. And then, in what feels like a casual wrap-up moment, they say, "You don't have anything in the car I should know about, do you? You don't mind if I take a quick look in the trunk?" Or they don't ask at all. They just say, "Go ahead and step out of the car for me." This is the search phase. This is what lawyers call the fishing expedition. The officer does not have enough evidence to arrest you, and they do not have a warrant to search your car. So they are looking for one thing and one thing only: your permission. You need to understand something vital about the Fourth Amendment. It protects you against unreasonable searches and seizures. Without your consent, without a warrant, and without probable cause, an officer generally cannot search your vehicle at a routine traffic stop. But there is a loophole officers use every single day: consent. If you say yes, the Fourth Amendment effectively disappears. No warrant needed, no probable cause needed. If you give permission, they can spend an hour dismantling your vehicle, and anything they find is completely admissible in court because you opened the door yourself. Verbal consent is legally identical to written consent. There is no difference in court. Go ahead. Sure, I have nothing to hide. You can check if you want. Those words are consent. Those 6 words, "I guess it's fine, go ahead," are a legal death sentence for your privacy in that moment. So here's exactly what you do the moment the officer returns your documents. Before they can pivot to the search phase, before they can ask the casual question that becomes consent, you ask this: "Thank you, officer. Am I free to go?" 6 words. Calm, direct, not a challenge, not confrontational, a clear, simple, completely legal question. This question matters for a specific legal reason. It forces the officer into a corner. Under the Supreme Court ruling in Rodriguez v. United States, decided in 2015, the court held that a traffic stop cannot be extended beyond the time needed to handle the original reason for the stop without independent, reasonable suspicion of a separate crime. Once the ticket is written and the documents are returned, the legal clock has run. Your question activates that protection immediately and puts the officer on notice. Most officers, if they have nothing concrete on you, will let you go rather than risk a lawsuit for illegal detention. If the officer says yes, you are free to go. You put the car in gear and you leave immediately. If they say no, you are not free yet, you now have critical information. You respond with this immediately and firmly. Officer, I do not consent to any searches. Repeat it like a record if you have to. Do not get out of the car unless directly ordered. Do not hand over your keys. Just state your non-consent clearly. Even if the officer proceeds to search anyway, and some will, by stating, I do not consent, your attorney can now file a motion to suppress in court. Because you did not give permission, the burden shifts entirely to the police to prove they had a legal basis to search. If they cannot prove it, the judge can throw out every single piece of evidence they found. Your words in that moment become a shield that reaches forward into any future courtroom. The wrong way. The driver who sits and waits for the officer to wrap up on their own timeline. The officer asks if there is anything in the car. The driver says no, nothing in there. Feel free to look. That is full legal consent. The search begins. 45 minutes later, the driver is standing on the side of the road, watching everything in their vehicle get pulled out and examined, wondering how this happened when they had nothing to hide. They gave it away with words they never had to say. The right way. Thank you, officer. Am I free to go? If yes, you leave. If they persist, I do not consent to any searches. No attitude, no panic, no explanation, just the words, stated once clearly. Now we reach the final phase, and this is the step that 95% of drivers skip entirely, even the ones who do everything else right. Everything in the first 3 phases happened during the stop. Now it is over. You are back on the road. And most drivers do one thing, they try to forget about it as quickly as possible. They shake it off, they go home, they try to move on. That is a mistake that could cost you significantly if anything from that stop ever reaches a courtroom. Here is the reality. The officer filed a report. They did it that same night. Every observation, every question they asked, every answer you gave. That report exists, it is detailed, it is time-stamped, and if your case ever reaches a courtroom, it is one of the most important documents in the proceeding. What do you have to counter it? Your memory, which fades within hours, which blurs under stress, which is, in a courtroom, your word against a trained officer's professionally written record. In the legal world, there is a saying, if it is not written down, it did not happen. But a written or recorded account created immediately after an event is what attorneys call contemporaneous documentation, and it carries significant weight before any judge. The moment you are safely away from the scene, pulled into a parking lot, sitting in your driveway, anywhere safe, you open your phone to the voice memo app or notes app, and you record or write down the following: the exact date, time, and specific location of the stop, the officer's name and badge number if you were able to see them on their chest or on the ticket, the stated reason for the stop, every question the officer asked you, every answer you gave, whether the officer touched your vehicle, where they touched it, and when, whether they asked to search, what you said in response, whether a K9 unit arrived at any point, how long the stop lasted from lights on to release. Start your recording with this exact phrase. This is a record of a traffic stop on, and then speak every detail clearly and consecutively. Voice memos are time-stamped automatically. That timestamp matters. A record created within minutes of a stop carries different legal weight than notes reconstructed days later from memory. The smart driver has a time-stamped voice memo from 11:42 at night on the night of the stop. They can say in court, Your Honor, I recorded my account 4 minutes after the stop ended. At no point did I grant consent, and I specifically asked, am I free to go? That turns your word into evidence. That creates reasonable doubt. That gives your attorney something concrete to work with. The wrong way. The driver shakes it off and goes home. 3 weeks later, a court summons arrives. They try to reconstruct what happened. They remember pieces. They cannot recall whether they said something specific or only thought it. Their attorney has nothing to work with except fading memory against a documented police report. The right way. Within 10 minutes of the stop ending, a time-stamped audio record exists that corroborates or contradicts the official report. If the officer's report says the driver made suspicious movements, but your recording reflects that both hands were on the wheel and announced that discrepancy is something a defense attorney can use, it turns your word into evidence. Let's run the entire thing from start to finish so you can see all 4 phases working together in a single real scenario. The wrong way first. It is a Friday evening. You get pulled over on your way home. Before the officer reaches your window, you immediately reach across to the glove box to have your registration ready. The officer notes the movement before they have even spoken a word to you. They approach, touch the taillight, and arrive at your window. You hand over the documents without saying a word about your hands. The officer goes back to the car. When they return, they hand back your license and ask where you were headed. You say you were at a friend's place, had a couple of drinks, nothing serious. The officer now has reason to investigate further. They ask if there is anything in the car. You say no and add that they are welcome to check. The officer takes you up on it. 45 minutes later, the stop is over. You have answered questions you were never required to answer, consented to a search you were never required to allow, and given the officer multiple documented observations, all from trying to seem cooperative. The right way? Same Friday evening, same stop. Before the officer gets out of the car, your music is off. Both hands are on the wheel at 10 and 2, and you are completely still. The officer approaches and touches the tail light. You do not flinch. You do not reach for anything. They arrive at your window. Good evening, officer. My hands are on the wheel. They ask for your documents. You say, my registration is in the glove box. May I reach for it? They say yes. You retrieve it slowly, deliberately, and hand it over. The officer runs your plates and returns. They hand back your documents and ask where you are headed tonight. Officer, I'm going to respectfully decline to answer additional questions. They pause. They ask if there is anything in the car you want to tell them about. Thank you, officer. Am I free to go? A moment. Then, yes. You drive away. You pull over 2 blocks later and record a voice memo with every detail of the stop while your heart is still beating fast. Total time, 9 minutes. No search, no incriminating statements, no escalation. A clean time-stamped record created immediately after. Same road, same night. Completely different outcome, based entirely on 4 things you knew going in. In just a few days, there is a new video coming on what to do the moment an officer says they smell marijuana coming from your car. Subscribe right now and hit the notification bell, because that scenario, more than almost any other on the road, is where drivers make catastrophic legal mistakes. It leads to more contested searches, more wrongful detentions, and more cases that completely fall apart in court simply because the driver said the wrong thing in the wrong 10 seconds. You will want to know exactly what to say before you ever face that moment. Not after. Here is everything compressed into what you need to remember before your next drive. The taillight touch is deliberate. It serves 3 purposes. Fingerprint evidence for the officer, a trunk safety check, and a startle test designed to produce observable reactions from you. Your response is both hands on the steering wheel, no movement, and 8 calm words when they reach your window. Good evening, officer. My hands are on the wheel. You are only legally required to provide your license, registration, and insurance. In most states, your name if directly asked. Every other question is completely voluntary. 1 calm sentence, I'm going to respectfully decline to answer additional questions, is all you need. No attitude, no explanation, no apology. The moment your documents are returned, you ask 6 words. Am I free to go? That question triggers your legal protection against an illegally extended stop, forces a direct answer before the consent trap can spring, and puts the officer on notice that the clock on this stop has run. If they say no, you respond immediately. I do not consent to any searches. And you repeat it if necessary. And the moment the stop ends, you create a time-stamped record of every detail while it is still fresh. That record is what gives your attorney something real to work with if you ever need one. These 4 things together are not tricks. They are not loopholes. They are constitutional rights, confirmed by Supreme Court decisions, used by practicing defense attorneys every single day in courts across this country. Hit subscribe so you do not miss the marijuana stop video. Smash the like button if this completely changed how you will sit in that driver's seat the next time those lights come on behind you. And drop a comment right now telling me which one of the 4 phases you had absolutely no idea about before today. Stay sharp, stay protected, stay safe.